Only on 10, we have some new information in the legal fight between a rape victim and Virginia Wesleyan College. We've been reporting the woman claims she was raped on campus, and the school didn't do anything to help her and is responsible for the attack. Well, tonight we are hearing another legal challenge about who is to blame. 10 on your side's Andy Fox is tracking these updates for us. Andy, what have you learned?
Nicole, this motion will be filed tomorrow, and it will ask a judge to strike or not allow Virginia Wesleyan to sue the alleged rapist who was kicked out of school for up to $10 million. The motion states the school is trying to get itself out of any and all responsibility, and the school wants the alleged rapist to pay any damages the school may end up owing the victim. In this court filing last week, Virginia Wesleyan College argues it does not have a legal duty to keep students safe. One does not have a duty to warn or protect another from third-party criminal acts. That Virginia Wesleyan is not responsible for the attack and is completely blaming the rapist named as Robert Rowe. The victim's attorney, Jonathan Halprin.
Bottom line is we're attempting to prevent the school from trying to blame the rapist in a case where legally it's not permissible for them to do so.
Tomorrow, Halprin will file this motion claiming both the college and the rapist are equally negligent and equally responsible, and one can't blame the other.
The law in Virginia does not allow you, if you are negligent, to sue and blame another and absolve yourself from negligence.
Halprin writes, Robert Rowe cannot be liable in contribution to defendant Virginia Wesleyan College because he is guilty of moral turpitude.
If you are negligent in your conduct, you cannot sue somebody else who's negligent, and you definitely can't sue somebody who was intentional in their conduct.
Wesleyan asked for indemnity, which is the act of not being held responsible. Halprin says there is no indemnity because that requires a contract, and there was no contract between the rapist and the school. Since there is no contract between Robert Rowe and Virginia Wesleyan College, express indemnity cannot lie. There also is no implied contract either.
What the school is attempting to do is shift all of the blame onto the rapist. The issue in the lawsuit is not whether the rapist committed the act. The issue in the lawsuit is whether the school was negligent.
Now, I emailed Virginia Wesleyan's attorney, and he said he had not seen this motion, so he would not and could not comment, but also wrote he found it surprising that the victim does not want to see the suspect be held financially responsible for his alleged acts. Jonathan Halprin told me the suspect is no longer in Virginia, is a student, doesn't have any money, and Halprin and the victim argue Virginia Wesleyan created the environment in which this attack took place. In the newsroom, Andy Fox, 10 on your side.